Usually when we talk about a medical diagnosis, there's this expectation of absolute precision.
Right, yeah.
It's almost like engineering, right? You fall off your bike, your arm swells up, you go to the hospital, and the x-ray shows that jagged white line on the screen. The doctor just points to it and says, there it is, that's the problem.
Yeah, it's entirely binary. I mean, the bone is either broken or it isn't.
Exactly. It's clean. It is completely visible, and as much as a broken arm hurts, that diagnosis is actually incredibly comforting. We like things to be visible. We like to be able to categorize our problems.
We crave certainty.
Yes, we want to know exactly where the boundaries of an issue lie so we can just fix it.
We do, but the moment you step out of the realm of physical science and step into the world of human behavior, that certainty just evaporates.
Oh, completely.
When you start dealing with legal ethics, professional accountability, human loyalty, that X-ray machine is suddenly completely useless. You're looking at a landscape that is, quite honestly, incredibly murky.
Which is exactly the messy, complicated world we are jumping into today. The lines of human loyalty aren't bright white like a fractured bone. But the justice system still has to figure out a way to map them out, right?
They have to try, yeah.
And that brings us to the massive overhaul that the Philippine Supreme Court initiated in 2023. They essentially looked at their decades-old rule book for lawyers, realized the x-ray machine was broken, and rewrote the entire thing.
It was a monumental shift. And frankly, it was desperately needed.
Now, this new code, it's a massive, sweeping document. It applies to every single lawyer in the country. But if you're listening right now, don't worry. We aren't going to just read through this thing like a dry legal syllabus.
No, that would be terrible.
That would take days. And honestly, it wouldn't be very helpful. Instead, we have a very specific mission for this deep dive. We are going to hyper-focus on two critical, rapidly evolving areas within this new ethical framework that completely redefine how the modern legal landscape operates.
And those two areas, while they might seem distinct at first, are deeply interconnected.
Right. First, we're going to clarify the fascinating new responsibilities and significantly elevated status of law students.
Huge changes there.
Oh, massive. And second, we are going to break down the meticulous, incredibly strict new requirements for identifying and disclosing conflicts of interest.
Because fundamentally, both of those topics deal with the exact same core questions. Who is actually allowed to practice law? And when they do, who are they allowed to be loyal to?
Okay, let's unpack this. Before we get into the actual mechanics of these new rules, we have to talk about why this overhaul happened in the first place. The previous rules governing lawyers in the Philippines were established all the way back in 1988.
1988. I really want us to just pause and think about what the world, and specifically the practice of law, looked like in 1988.
I mean, I'm trying to picture it. 1988 is practically the dark ages when it comes to modern communication.
It really is.
It's pre-internet for all practical intents and purposes. There were no smartphones. There was absolutely no social media. If a lawyer wanted to research a case, they were spending hours physically digging through heavy, leather-bound volumes in a dusty library.
Yeah, exactly.
If they wanted to communicate with a client, it was a landline phone call or a typed letter sent through the physical mail.
Precisely.
Yeah.
And the world they operated in was much, much smaller. The preamble of this new 2023 document explicitly points out that after more than 3 decades, the role of the modern-day lawyer has fundamentally expanded and shifted.
Right.
They've transitioned from being just courtroom advocates to becoming mediators, peacemakers, and highly specialized consultants. They operate globally now. And crucially, the technology has fundamentally altered the speed and the reach of their actions.
The document specifically cites the Supreme Court's push toward a technology-driven judiciary. We're talking about digitization, automation, and the entirely new behavioral minefield of social media and the internet.
A literal minefield.
Because in 1988, a lawyer wasn't lying awake at night worrying about whether a casual comment on a public message board accidentally violated attorney-client privilege.
No. Their ethical perimeter was essentially the walls of their office and the doors of the courtroom. Today, that perimeter is digital, it's instantaneous, and it's permanent.
Wow, yeah.
Permanent. But what I find truly fascinating about this new code is how it approaches the very concept of ethics. It doesn't just hand down a list of dry, sterile commandments. It gets incredibly philosophical right out of the gate.
It does.
It describes ethics as the experiential manifestation of moral standards.
I noticed that too. It's actually acknowledging the human element. There's a specific part in the preamble that I found really striking. It explicitly acknowledges the unique identity of the Filipino lawyer.
Yes, the cultural content.
It says that the standards embodied in this code uniquely address the characteristics of the Filipino lawyer as an amalgamation of various influences: familial, cultural, religious, academic, political.
Which is a brilliant and frankly very necessary acknowledgement of reality.
Mhm.
The text explicitly states that inherently, as a social being, the lawyer inevitably develops and cultivates relations, preferences, and biases.
Right.
Think about the cultural context here. The Philippines is a highly relational society. Concepts like deep familial loyalty extending far beyond the nuclear family are paramount. There are intricate social obligations and long-standing community ties.
Right. You can't just pretend those things don't exist. You can't just put on a suit and suddenly become a perfectly objective, emotionless robot who only cares about cold, hard statutes.
Exactly. The code isn't pretending the robot exists.
Yeah.
It acknowledges those deep cultural and familial ties, but it demands a conscious, deliberate adoption of ethical standards to balance those personal human choices against the rigid demands of right and justice. It is setting a baseline.
It's essentially saying, look, we know you have a family, we know you have friends, fraternities, cultural obligations, we know you live in a complex, deeply interconnected society. But when you step into the role of an officer of the court, you are bound by a fiduciary trust that has to supersede all of that.
That's exactly it.
And I think that's why this matters so much to whoever is listening right now. Whether you are a prospective law student, someone who might actually need to hire a lawyer one day, or just a citizen trying to understand how the gears of the justice system turn. Understanding these rules shows you how legal loyalty is manufactured and regulated.
It pulls back the curtain on the entire profession. So, with that philosophical foundation in place, let's look at how this new code actually redefines who gets to turn those gears. Because, as we're about to see, the definition of a legal practitioner has expanded significantly.
Which brings us to the first major pillar of our deep dive: the changing landscape for law students. To understand how radical this shift is, we first have to understand the traditional boundary lines. There is a very strict rule regarding what they call non-delegable legal tasks.
It's a crucial firewall.
Hmm.
The practice of law is restricted and licensed for a very good reason.
Right. The stakes are so high.
You are dealing with people's liberty, their life savings, their families. You can't just let anyone hang up a shingle and start dispensing legal advice.
Right. So the general rule is uncompromising. A lawyer cannot delegate tasks that require independent legal judgment to a non-lawyer, and that explicitly includes paralegals.
Yes, very strictly.
A code provides a very clear restrictive list of what a paralegal cannot do. They cannot accept cases on behalf of the lawyer. They cannot give legal advice or draft a legal opinion. They cannot act independently without direct supervision.
They do incredible, vital work, but it is strictly organizational and foundational.
Exactly. The code says they cannot hold themselves out as a lawyer. They can't be named in association with a lawyer in a formal pleading. They cannot appear in court. They cannot conduct negotiations, and they absolutely cannot sign correspondence that contains a legal opinion.
The paralegal is officially defined in the text as someone employed for non-diagnostic and non-advisory work.
To go back to our medical analogy from earlier.
Exactly. To go back to that, they can schedule the x-ray, they can prep the patient, they can organize the medical files,
Yeah.
but they cannot diagnose the fracture or recommend the surgery. That diagnostic and advisory function is the sacred, restricted domain of the licensed lawyer.
Okay, but here is where the massive twist comes in. Built right into the text of this strict prohibition, after listing all those things that non-lawyers absolutely cannot do, the section ends with a single foundational exception.
The game changer.
It says, these provisions shall not apply to law student practitioners under the rules of court.
And with that one sentence, the entire paradigm of legal education and early practice shifts entirely.
It's a huge leap. I mean, it sounds like law students aren't just fetching coffee or quietly highlighting textbooks in the back of the library anymore.
Not at all.
To stick with the medical analogy, they are being handed the scalpel. They are actually allowed to give advice, appear in court, and perform the exact diagnostic tasks that a seasoned paralegal is strictly forbidden from doing.
That is a highly accurate way to look at it. They are stepping out of the theoretical world of the classroom and stepping into the very real, very high-stakes world of actual legal practice.
Wow.
The code introduces this concept of limited legal services rendered by law student practitioners. This is done under a very specific framework called the Clinical Legal Education Program.
So they are handling real cases for real people.
Yes. But, as you said, they are handed the scalpel, but the attending surgeon is standing right over their shoulder.
Okay, that makes sense.
The code places an immense, almost staggering weight on the institutions and the specific individuals facilitating this. It mandates that a law student clinic director and the supervising lawyer must provide meaningful training. But the critical, terrifying part for the supervisor is this. They shall assume total responsibility for any work performed by the law student while under their supervision.
Okay, I want to push back on this a little bit because I'm trying to put myself in the shoes of a seasoned 20-year veteran lawyer.
Let's hear it.
I have my license. I have my reputation. I'm supervising a 23-year-old law student, someone who hasn't even taken the bar exam yet. And if they make a mistake while giving these limited legal services, I am the one who is held entirely responsible.
Ethically and professionally, yes.
That seems, honestly, that seems paralyzing. If we look at the specific rules governing responsibility over a subordinate, it says a supervisory lawyer has to co-sign pleadings with the supervised student. And it explicitly says the supervisor is responsible for violations if they ordered the conduct, or if they knew about it and failed to prevent it. But there's one fascinating phrase here regarding liability for mistakes that cause damage. It says the supervising lawyer is responsible unless they can prove they exercise the diligence of a good parent of a family in selecting and supervising that student.
The diligence of a good parent of a family. It's a beautiful phrase, isn't it?
It really is.
It's a classic standard in Philippine law, heavily derived from Roman civil law traditions, the concept of paterfamilias.
It's incredibly evocative. But what does that actually mean in the context of a bustling law firm or a crowded legal aid clinic? If I have to prove I acted like a good parent to avoid being disbarred because my law student gave bad advice during a negotiation, am I just going to micromanage them to death?
That's the fear, yes.
Doesn't the fear of liability mean the training ceases to be meaningful because the supervisor is too terrified to let the student do anything real?
That is the exact tension the rule is trying to navigate. The phrase, diligence of a good parent of a family, implies a standard of ordinary, reasonable, and prudent care. It does not mean you are expected to be omniscient.
Okay.
It doesn't mean you have to hold their hand every single second. What it means is that you trained them properly before they spoke to the client. You set up robust safeguards. You reviewed their drafted documents reasonably thoroughly. You made sure they understood the boundaries of their competence.
So you didn't just throw them to the wolves?
Exactly. If you just hand a second-year law student a thick case file, point him toward the courthouse, and say, go handle this hearing, good luck, tell me how it went, you have absolutely failed to exercise the diligence of a good parent.
Right, because that's essentially abandonment.
You have abandoned them. And if they make a critical error that damages the client's case, that falls squarely on you.
I see. So it's not about hovering over them constantly. It's about building a structure of competence around them.
Precisely. And if we pull back and look at the bigger picture here, this isn't just about figuring out who is liable for a typo in a contract. This is a deliberate systemic culture shift. The Supreme Court is trying to breed ethical practitioners from day one.
Right.
There is a specific mandate in the new code regarding support for legal internship and training. It explicitly commands lawyers to prepare the next generation for ethical practice. And it uses a very specific phrase. The lawyer shall treat the apprentices as junior colleagues and future counsels.
Junior colleagues and future counsels, that is a massive elevation in status.
It is.
They are not underlings. They aren't just cheap labor brought in to do endless document review for 20 hours a day in a windowless room.
Right. It elevates the student and integrates them into the profession's ethical fabric long before they ever take the oath. They are subject to the exact same strictures of confidentiality, diligence, and competence as fully licensed lawyers. By making the supervising lawyer strictly accountable, but providing that good parent offense, the system is forcing senior lawyers to actively, conscientiously mentor rather than passively exploit these law students.
That is a profound shift in the power dynamic. So if you are a law student listening to this, you need to understand that under these new rules, you are no longer just sitting in the waiting room waiting for your career to start. You are in the arena.
You're in it.
The ethical burdens of the profession are already resting heavily on your shoulders, right alongside your supervising lawyer.
Which naturally brings us to the next massive question. Now that we have established who is actually allowed to practice law, which now actively includes these newly empowered law students, We have to ask the most complicated question in the entire legal profession. Who are they allowed to represent?
And that pivots us directly into the concept of conflicts of interest. Now, conflict of interest is a phrase that gets thrown around casually all the time. We hear it in corporate boardrooms, we see it in political scandals. It's a staple of pretty much every legal drama on television.
Oh, constant.
But the new code defines it with an absolute, uncompromising precision that is frankly fascinating.
Because it is the absolute bedrock of legal ethics. Think of it this way. If independence and objectivity are the armor of a lawyer, avoiding conflicts of interest is the structural integrity of that armor. If there's a crack in it, the whole thing fails.
The general rule seems simple on the surface. The code states plainly that a lawyer shall not represent conflicting interests except by written, informed consent of all concerned, given after a full disclosure of the facts.
It's a simple sentence, but every single word in it is doing heavy lifting.
Right. And what I really appreciate is that the text doesn't just leave conflict of interest as some vague, abstract concept. It provides a highly specific, visceral legal test.
Yes, the test is crucial.
It says a conflict exists when a lawyer represents inconsistent or opposing interests of two or more persons. And the exact test is this. Whether in behalf of one client it is the lawyer's duty to fight for an issue or claim, but which is his or her duty to oppose for the other client.
The fight versus oppose test.
It's such a brilliant way to frame it. I was trying to come up with a real-world analogy for this, and the best I could think of is chess.
Okay, let's hear the chess analogy.
Imagine you are a professional chess player, and you are hired to play a match. But you are hired by both sides simultaneously.
Okay, yeah.
You literally cannot strategize to checkmate the Black King while simultaneously being paid by the guy across the table to protect that exact same Black King. Every single move you make to fulfill your duty to one client inherently necessarily violates your duty to the other.
That is a perfect analogy. You cannot be the sword and the shield in the exact same battle. The human brain cannot compartmentalize loyalty to that degree when the goals are mutually exclusive.
But the rule doesn't just stop at identifying the conflict and banning it outright. It provides an exception. But that exception is a remarkably, almost impossibly high bar to clear. It's that phrase you mentioned. Except by written informed consent of all concerned given after a full disclosure of the facts.
I want us to really drill down into that phrase, written informed consent. It is not enough to just casually mention a conflict over coffee.
Right.
You can't just call up client A and say, hey, just a heads up, I'm also doing some contract work for client B, who you're currently in a massive lawsuit with. Cool.
Right. A verbal, yeah, sure, whatever, just doesn't cut it.
Absolutely not. And we need to explore why the standard relies so heavily on the word written and the word informed. The code establishes early on that the lawyer-client relationship is of the highest fiduciary character.
Highest fiduciary character. Let's unpack that. Fiduciary basically means it is a relationship founded entirely on trust, right?
Yes. It means the client is consciously, voluntarily, and often in a state of deep vulnerability, vesting the lawyer with their absolute confidence. They're handing over their secrets, their financial security, sometimes their actual physical liberty.
That's a lot of power to hand over.
It is. So without a formalized, detailed, written disclosure that lays out exactly what the conflict is, exactly what the strategic risks are, and exactly what it means for the client's specific case, that fiduciary trust is an illusion.
So informed means they actually have to understand the downside. They have to understand how this could blow up in their face.
Exactly. If lawyers are secretly or even casually playing both sides of the chessboard without explicit documented permission, the public's faith in the impartiality of the entire justice system crumbles. The written consent is the proof.
Proof that they understood.
Exactly. It proves that the client wasn't just briefly told about a potential issue in passing, but that they deeply understood the risk. They weighed their options, and they consciously chose to accept that risk anyway.
And frankly, it protects the lawyer just as much as the client. If it is in writing, signed, and dated, there is no debate 3 years later during a malpractice suit about who said what.
Absolutely.
So we have this robust fight versus oppose test. But a conflict of interest isn't just a snapshot of who is currently sitting in your waiting room.
Far from it. That's probably the most common misconception. People think a conflict only exists in the present tense. In reality, it is a continuum.
And this is where the rules get incredibly intricate. The code establishes what I like to think of as a timeline of trust. Your ethical obligations to a person do not simply spring into existence the moment they sign a retainer agreement, and they absolutely do not vanish the moment the trial is over.
No, they don't.
You are navigating a lifelong timeline of everyone you have ever spoken to in a professional capacity.
Let's walk through that timeline, starting at the very beginning, the moment of first contact.
Okay, so we're looking at the rules regarding prospective clients. This is someone who just walks into your office off the street or maybe calls you up for an initial consultation. The new rules dictate that a lawyer must, at the earliest opportunity, ascertain if there is any conflict between this prospective client and the firm's current clients.
You have to run the conflict check immediately. You cannot sit there, let them tell you their entire deeply personal life story for an hour, and then at the end of the meeting say, oh, wow, that's a tough situation. By the way, I currently represent the guy you were trying to sue, so I can't help you.
Because at that point, the damage is already done. You already possess their secrets, and the rules are incredibly strict about those secrets. It says a lawyer shall maintain the private confidences of a prospective client even if no engagement materializes, and you cannot use that information to further your own interest or the interest of any current client.
Let's play it a hypothetical here, because this happens way more often than people think. Imagine you are a brilliant software developer, and you want to sue your former business partner for stealing your code. You go to the top intellectual property lawyer in the city. You sit in their office, you show them the code, you explain your entire legal strategy, you reveal your financial weaknesses, you spill your guts. But at the end of the meeting, the lawyer tells you their hourly rate is just too high, you can't afford them. So you walk away, and no contract is ever signed.
Okay, I'm with you. So there's no official relationship.
Right. But a week later, your former business partner, the one who stole your code, walks into that exact same lawyer's office and says, I have plenty of money, and I want to hire you to defend me against this software developer.
Oh, wow. So what does the lawyer do? I mean, they didn't sign anything with the first guy.
It doesn't matter. The lawyer is entirely bound by confidentiality to the first developer, even though not a single peso ever changed hands. The lawyer cannot accept the case from the business partner if it means using or risking the confidential information they learned during that initial unpaid consultation.
Wow.
The timeline of trust begins the absolute second the professional consultation begins.
That is rigorous. And I guess it stops people from just shopping around and deliberately conflicting out all the good lawyers in town by spilling secrets to them, right? Because the rules also have provisions on how to screen lawyers if they do receive that information.
Yes, exactly. There are screening provisions.
Okay, so moving along the timeline. What happens when they actually sign the contract? What are the rules for current clients?
This is where the rules delve deeply into the financial and personal entanglements between a lawyer and their client. It goes way beyond just the basic don't represent the opposing party in court rule.
The financial barriers are fascinating. For example, a lawyer cannot enter into a business transaction with a client or acquire an ownership interest adverse to the client.
Right.
There is an exception, but it's steep. The terms have to be fair. There has to be full written disclosure. The lawyer actually has to advise the client in writing to go get an independent lawyer to review the deal, and then they need written informed consent.
Think about the psychology of the power dynamic here. The client has come to you because they trust your judgment implicitly. They rely on your expertise. If you turn around and say, hey, I think you should invest in this real estate venture with me, the client is not evaluating that business deal objectively.
No.
They're evaluating it through the lens of their reliance on you as their legal protector. It inherently skews their judgment.
It's almost a subtle form of coercion, even if it's unintentional. And the rules build an even higher wall. No acquiring a substantial gift from a client, including a testamentary gift. Meaning, you cannot draft a will for a client that conveniently leaves you their summer house.
Exactly. Huge red flag.
Furthermore, during the engagement, a lawyer is strictly prohibited from lending money to a client, except under very specific, urgent, justifiable circumstances. And they cannot borrow money from a client either.
The rationale there is purely about preserving independence. If you owe your client a massive amount of money, or if they owe you a massive amount of money entirely separate from standard legal fees, your professional judgment is immediately compromised.
It's totally muddied.
Are you advising them to settle this lawsuit quickly because it's genuinely the best legal strategy?
Right.
Or are you pushing them to settle because you know they need the payout to pay back the personal loan you gave them? It muddies the waters of objectivity to a dangerous degree.
I totally understand the logic there, but I have to say, out of all the rules regarding current clients, there is one highly specific restriction that completely caught my attention. It feels like such a sign of the times. I want to read this exactly because it's just so fascinating.
Let's hear it.
The rule states, Unless with the written informed consent of the client and subject to the application of the sub judice rule, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation.
Ah, yes. The media rights ban.
The media rights ban. I read that and immediately thought, is the Supreme Court actively watching the massive boom in true crime podcasts and Netflix legal documentaries?
I would be surprised.
Are they looking at this entire industry of monetized legal drama and saying, we have to stop lawyers from cashing in on their own clients? Because it feels incredibly specific to the era we're living in right now.
It is absolutely a reaction to the modern media landscape.
Uh-huh.
But it's not just about preventing lawyers from getting rich or famous. If we dig into the underlying mechanisms here, it is rooted in the deepest psychology of justice and motivation.
Wait, really quickly before we get into the psychology. The rule mentions subject to the application of the sub judice rule. I've seen that term before, but what exactly does sub judice mean in practical terms?
It's an essential concept. Sub judice literally translates to under judgment. The rule basically means that lawyers and the parties involved are restricted from making public comments or disclosures about a pending case that could sway public opinion or influence the judge or jury.
Okay, so no trying the case in the media.
Exactly. It's designed to protect the integrity of the ongoing trial. You can't try the case in the media before it's decided in the courtroom.
Okay, that makes perfect sense. So back to the media rights ban. How does this tie into the psychology of a lawyer's motivation?
Think about what a lawyer is actually supposed to do. Their primary mandate is to provide competent, efficient, and zealous legal service to their client. The ultimate goal should be to resolve the client's issue as favorably and as quickly as possible.
Right, the client just wants the nightmare to end.
Exactly. Sometimes, the absolute best thing for a client is a quiet, confidential settlement out of court, avoiding any unnecessary public spectacle or emotional trauma.
Get in, win the case quietly, and get out.
Precisely. But now imagine that same lawyer has secretly or even openly negotiated a lucrative contract to sell the exclusive book or movie rights to the trial they are currently arguing.
Oh, wow.
Suddenly, their financial upside isn't just their standard hourly fee. Their payout is now directly tied to the commercial viability of a potential streaming deal.
I see exactly where this is going.
If they secure those media rights during the ongoing case, their internal motivation might shift, perhaps even unconsciously. A quiet, efficient settlement out of court makes for a terrible movie. It's boring.
Right. Nobody is watching a Netflix doc about a quiet settlement. But a long, drawn-out, highly dramatic, headline-grabbing trial with surprise witnesses, screaming matches, and emotional outbursts, that makes for a hit true crime documentary.
Exactly. The lawyer might start making procedural choices, delaying the trial, putting a vulnerable witness on the stand, aggressively cross-examining someone unnecessarily, not to safeguard the client's liberty, but to increase the dramatic tension of the narrative they are trying to sell to a production company.
That's horrifying.
It creates a profound, almost existential conflict of interest between the client's actual liberty and the lawyer's future wallet.
That is terrifying, but it makes so much sense. The rules are acknowledging human nature. They recognize that the temptation to be the star of a documentary or to write a best-selling book might completely override the fundamental duty to protect a vulnerable client. It ties right back to what we discussed at the beginning. The code is stepping in to regulate personal biases and ambitions against the demands of justice.
It demands that the lawyer's sole focus remains on the client's legal well-being, not their own media brand.
Okay, so that covers prospective clients and current clients. Let's finish the timeline. What happens when the case is over? We're looking at former client.
Even when the gavel falls and the contract ends, the trust remains.
The rule is unambiguous. A lawyer shall maintain the private confidences of a former client even after termination of the engagement. But it goes further than just keeping secrets. It states that unless the former client gives written informed consent, a lawyer who has represented a client in a legal matter shall not thereafter represent a prospective client in the same or a related matter where the prospective client's interests are materially adverse to the former client.
In simple terms, you cannot switch sides on the same issue.
Because you know where all the bodies are buried. For example, if you represented a husband in meticulously drafting a prenuptial agreement, you cannot, 5 years later when things go sour, turn around and represent the wife in trying to break that exact same prenuptial agreement.
Exactly. You drafted the document, you know its weaknesses, you know the husband's financial secrets that informed it. Using that knowledge against him later is a fundamental breach of loyalty.
Right.
Now, there's a small caveat regarding information. You cannot use information relating to the former representation to their disadvantage unless that information has become generally known.
What actually constitutes generally known? Because that seems like a loophole. Does it just mean a rumor is floating around on Twitter?
No. Generally known is a very high bar to clear. It doesn't mean a rumor, and it doesn't even necessarily mean it's buried in an unsealed court document that nobody's ever read. It generally means the information is public knowledge, widely accessible, and widely recognized by the public or within the relevant industry.
Okay, so it has to be truly public.
Yes, barring that very narrow exception, the timeline of trust is essentially permanent.
Okay, so up to this point, we've been talking mostly about individual lawyers. It is relatively easy to spot a conflict when you are a solo practitioner sitting in a single office. You know who you've talked to, you know who your clients are. But what happens when you leave the solo office and introduce dozens or hundreds of other lawyers into the mix?
The complexity doesn't just add up, it multiplies exponentially.
Which brings us to the next major area of our deep dive, the institutional minefield. Navigating conflicts within massive law firms, corporations, and legal aid organizations. Let's start with law firms. The concept of firm-wide contamination.
It sounds like a biohazard term, but it's incredibly accurate for legal ethics.
It really does. The rule dictates that when a lawyer joins a new law firm, it is their absolute duty to disclose to the new firm, at the earliest possible opportunity, all of their previous clients that might have a potential conflict with the current clients of the new firm. It really makes it seem like a newly hired, brilliant lateral lawyer isn't just a great asset, they are a walking ethical liability.
They absolutely are. When a lawyer moves from firm A to firm B, they don't arrive with a clean slate. They carry that entire timeline of trust of every single client they handled at firm A right through the front door with them.
That's a lot of baggage.
Let's say firm B is currently in the middle of a massive lawsuit against a particular tech company. If the newly hired lawyer used to represent that exact tech company at their old firm, their mere arrival could potentially contaminate the entire new firm.
Wait, so firm B could be disqualified from a case they've been working on for years just because they hired one new guy?
Yes, unless immediate, strict, documented screening measures, often called ethical walls, are implemented. The new lawyer has to be completely walled off from the case. They can't access the files, they can't discuss it in the break room, they can't share in the fees generated by it.
The rules are trying to prevent even the accidental slip of a secret over the water cooler.
Exactly.
Now, what about lawyers who don't work for a firm but work directly for a company? Corporate lawyers. The code clarifies this in a way I found really helpful. It states that a lawyer who represents a corporation does not, by virtue of such representation, necessarily represent any constituent or affiliated organization, like a parent company or a subsidiary.
This establishes what we call the entity theory. The corporation is a distinct, abstract legal entity.
Right. So just because you represent a massive multinational holding company, it does not automatically mean you represent the tiny subsidiary they bought last week. And more importantly, and I imagine this is where it gets really awkward, it doesn't mean you represent the individual human executives or the board of directors or the shareholders. Your loyalty is to the abstract entity of the organization itself.
You can imagine how messy that gets in practice.
Yeah.
A CEO comes into the in-house counsel's office, shuts the door and says, "Hey, I need some quick legal advice on this personal tax issue," or worse, "I think I might have accidentally engaged in insider trading. What do we do?"
That is a nightmare scenario.
It is, because the lawyer has to immediately stop them and clarify, "I am not your lawyer. I am the company's lawyer.
Yeah.
If what you are telling me harms the company, my duty is to report it to the board, not to keep your personal secret."
Wow.
The corporate lawyer must constantly, vigilantly clarify who the client actually is.
But out of all these institutional rules, the most fascinating dynamic, and I think the most important one for the general public to understand, is the contrast between standard legal aid clinics and the government's public attorney's office, the PAO.
This is one of the most brilliant, highly pragmatic contradictions in the entire rulebook.
Let's lay out the contradiction. First, we have the rule for standard legal services organizations like a private NGO or a university legal aid clinic. The code states, all the lawyers of the legal services organization who participated in the handling of a legal matter shall be covered by the rule on conflict of interest and confidentiality.
Right.
So, if lawyer A at the clinic represents the plaintiff in a dispute, lawyer B at that exact same clinic cannot represent the defendant. The conflict covers the entire organization.
That is the standard rule of imputed conflict. The entire organization is essentially treated as one giant multi-headed lawyer.
Right. But then we flip to the rule specifically designed for the public attorney's office. It says a conflict of interest of any of the lawyers of the public attorney's office incident to services rendered for the office shall be imputed only to the said lawyer and the lawyer's direct supervisor.
Huge exception.
And it explicitly clarifies that this shall not disqualify the rest of the lawyers from the public attorney's office from representing the affected client.
Provided, of course, that there is full disclosure and written informed consent.
But why does this massive exception exist? Why does a private legal clinic get totally disqualified by a conflict, but the government's PAO can essentially have two lawyers who work for the exact same massive organization actively fighting against each other in court? Isn't that the definition of a conflict?
On paper, in a purely theoretical ethical vacuum, yes, it is a conflict.
Yeah.
But law doesn't exist in a vacuum. It exists in a flawed society.
Yeah.
We have to look at the vital why behind this rule. And the text actually provides the exact socioeconomic rationale. It states that the PAO shall ensure ready access to its services by the marginalized sectors of society in a manner that avoids situations which will leave these marginalized parties unassisted by counsel.
Leave these marginalized parties unassisted by counsel. That is the driving force here.
Exactly. Let's really explore the reality of this. The PAO is the primary and often the only legal aid service provided by the government. The people they serve are defined as indigent individuals who literally do not have money or property sufficient for food, shelter, and basic necessities.
The most vulnerable people.
Now, imagine a rural province where there's only one PAO office serving several towns.
Okay, I'm picturing it.
Let's say an indigent woman goes to that local PAO office desperately seeking a protection order against her highly abusive husband. She needs immediate legal intervention to protect her life.
But what if her abusive husband had already gone to that exact same PAO office, or even a PAO office in a neighboring town, maybe 3 years ago, to get help with a minor property dispute or a traffic violation?
If the strict private firm rule of imputed conflict applied to the PAO across the board, the fact that the husband was a former client of the organization would mean the entire PAO system is conflicted out.
The entire institution would be barred from representing the wife.
Yes, and because she is indigent, she cannot afford to hire a private lawyer. She has no other options. The rigid application of a purely theoretical conflict of interest rule would result in a marginalized victim being completely, devastatingly denied access to justice.
The rule would actually hurt her.
The ethical rule designed to protect people would actually victimize her.
That is a staggering realization.
The Supreme Court recognized this reality. This specific rule is a necessary, profoundly pragmatic ethical compromise. By localizing the conflict only to the specific handling lawyer and their direct supervisor, they are ensuring that the ethical pursuit of perfect loyalty does not accidentally become a weapon that deprives the poorest members of society of legal representation.
It's an incredible balancing act. It goes right back to the preamble we talked about at the very beginning, balancing the rigid rules against the actual messy demands of right and justice. For the PAO, providing baseline access to justice for the marginalized heavily outweighs the theoretical purity of an organization-wide conflict imputation.
It is a perfect example of the law adapting to the harsh socioeconomic realities of the society it governs.
Which is actually a perfect pivot into our final major topic today. Because we've talked about conflicts inside law firms and conflicts inside government offices, but conflicts of interest haven't just multiplied within massive organizations. They have spilled out of the physical legal workspace entirely.
Oh, definitely.
They are happening in classrooms and they are happening on our phones.
These are the modern, unconventional frontiers of legal ethics.
Let's start with the classroom. There is a whole section dealing with practicing lawyers who are also in the academe. The rule states that if you are a law school dean or a faculty member, you still have to adhere to the code. You don't magically stop being a lawyer just because you're standing in front of a whiteboard.
Right.
But there is a specific conflict rule here. A lawyer serving in an educational institution must disclose to the institution any adverse interest of a client.
Which is entirely logical. A university might be involved in massive litigation, maybe a land dispute or a labor issue, and you cannot be secretly representing the entity that is actively suing the university that employs you to teach.
Right. But it's the second paragraph of this rule that I found truly fascinating because it brings our two main focuses for this deep dive perfectly together: law students and conflicts of interest.
It's a great intersection.
It states, Upon discovery of any adverse interest of the lawyer's client, which directly affects any student who is under his or her direct supervision and guidance, the lawyer shall likewise disclose the same to the institution.
That is a highly specific, very nuanced, and absolutely necessary rule.
It is. Let's build a scenario around this. You are a highly successful practicing lawyer, and you are currently representing a massive real estate developer in a very aggressive eviction case against a group of tenants. At the same time, you are an adjunct professor teaching property law at a local law school. Midway through the semester, you realize that the family being evicted by your developer client is actually the family of one of the students sitting in the front row of your class.
The power dynamic in that room instantly becomes incredibly fragile and toxic.
Right. Your client's interest is directly adverse to the survival of your student's family.
And you're the one grading that student. You're assessing their competence. You have the power to impact their future career. And yet, in your professional life outside the classroom, you are actively working to their profound detriment.
That's a huge conflict.
The code mandates disclosure here, because that hidden conflict could lead to a whole host of ethical disasters. It could lead to unconscious bias in how you grade their exams. It could lead to the student feeling intensely intimidated and unable to learn. Or worse, the lawyer might exploit knowledge they gain about the student's family through casual classroom interactions to benefit their client's case. It protects the sanctity and safety of the educational environment.
It just goes to show how deep and invisible the roots of a conflict can be. But if the classroom is a controlled, regulated environment, our next and final battleground is the exact opposite. It is total chaos. We have to talk about social media.
The absolute Wild West of ethical violations.
The new code dedicates a massive section specifically to the responsible use of social media. And reading through it, it really feels like the Supreme Court is actively trying to rein in a lot of very public, very bad behavior online.
It is a direct, forceful response to the era of virality, where a lawyer's impulsive thought can be broadcast to 1 million people in seconds.
First of all, the code establishes a fundamental duty to understand the benefits, risks, and ethical implications associated with the use of social media. So I'm just a boomer, I don't know how Facebook works, defense is officially dead.
Completely dead.
You cannot claim technological ignorance anymore, but then it gets incredibly specific about behavior. It states, a lawyer shall not knowingly or maliciously post, share, upload, or otherwise disseminate false or unverified statements, claims, or commit any other act of disinformation.
Think about the weight of that. The fight against fake news and online disinformation is no longer just a civic duty. It is now a strict ethical mandate for licensed lawyers.
And it goes further. It explicitly prohibits fraudulent accounts. It says a lawyer cannot create or operate social media accounts to hide their identity for the purpose of circumventing the law.
Yeah.
So no secret burner accounts to viciously troll opposing counsel.
Right.
No fake profiles to secretly dig up dirt on a witness or stalk a jury member.
The anonymity of the internet does not shield you from the code of professional responsibility. You are a lawyer, whether your username is your real name or Justice Warrior 99.
I love that. And then there is the issue of confidentiality online. It prohibits revealing client information in posts, obviously, but it takes it a step further regarding digital security. If a lawyer uses a social media account or a messaging app to communicate about client info, they shall exert efforts to prevent the inadvertent or unauthorized disclosure or use of or unauthorized access to such an account.
This is crucial. If your WhatsApp or your Messenger account gets hacked because you used password 123 or you clicked on a blatant phishing link and your client's highly sensitive secrets leak onto the internet, you are ethically liable.
Because it was preventable.
Because you failed to safeguard the digital perimeter, just as you would be liable for leaving physical confidential client files spread out on a table in a busy public coffee shop.
But the part that really brings us all back to our core theme is the rule regarding online posts that could violate conflicts of interest. The code demands that a lawyer exercise prudence in making posts or comments that could violate the provisions on conflict of interest. So I want to ask you, what does this actually look like in practice? How does a modern lawyer, or even a young law student doing those limited legal services we talked about, navigate a world where a casual tweet or a hot take comment on a viral TikTok video could potentially trigger a career-ending disciplinary action?
This raises what I believe is the most important question about the fundamental nature of the legal profession today. The modern lawyer and the modern law student must live with a heightened, constant state of situational awareness that previous generations simply never had to consider.
Because the audience is different.
Exactly. In 1988, your audience was the judge, the opposing counsel, and maybe the handful of people sitting in the gallery of the courtroom. Today, your audience is global, it is instantaneous, and it is permanently archived.
So true.
A lawyer aggressively tweeting a deeply polarizing political opinion on a controversial legal issue might inadvertently conflict themselves out of representing a future client who requires them to argue the exact opposite view in court. They might inadvertently reveal a deep-seated bias that violates the fight versus oppose test before the client even walks in the door.
So they are no longer just legal advocates from 9 to 5 and then off-the-clock citizens on the weekends?
No, they are fiduciaries of trust in every single aspect of their public and private lives. The new code is making it abundantly clear that the title of attorney is not a coat you take off and hang up in the closet when you log on to Twitter or Instagram. It is a permanent marker of your obligation to the administration of justice.
And that profound obligation applies whether you are a seasoned Supreme Court litigator or a third-year law student acting as a junior colleague. Okay, we have covered an immense amount of ground today. We've gone from the theoretical to the intensely practical. Let's try to bring this all together for our listener.
I think we've managed to map out the contours of this new landscape quite thoroughly.
We really have. We've seen how this 2023 code has fundamentally elevated law students. They aren't just reading textbooks. They are stepping into the arena, holding real legal responsibilities, while their supervising lawyers are tasked with exercising the diligence of a good parent to build a framework of competence around them.
A huge step forward.
And we've mapped the exhaustively strict, lifelong rules regarding conflicts of interest. We explored the fight versus oppose test, the permanent timeline of prospective, current, and former clients, the psychology behind the media rights ban, the contamination of law firms, the brilliant pragmatic exception for the PAO to protect the marginalized, and the absolute ethical minefield that is social media.
It is a truly comprehensive framework for ethical survival in the 21st century.
And I want to speak directly to you, the listener, for a moment. Why does any of this matter to you? Why should you spend an hour caring about the internal administrative disciplinary rules of the legal profession? Because whether you are hiring a lawyer to draft a simple contract for your small business, or you find yourself facing a massive trial that could alter the entire course of your life, or even if you are just a citizen trying to understand the news and how society functions, these guardrails, these exact hyper-specific rules we discussed today are the only things that guarantee the system actually works.
Yes.
They are what guarantee that the person standing next to you, the person fighting for you, is entirely, uncompromisingly loyal to you alone. Without these rules, the justice system is just a chaotic marketplace of shifting loyalties and hidden agendas. With them, it is a foundation of trust.
I couldn't agree more. That trust is the currency of the entire system. But before we sign off, I want to leave our listener with one final, perhaps slightly unsettling, provocative thought to mull over.
Oh, I love these. Let's hear it.
We spent this entire deep dive talking about the rules governing human lawyers and human law students. And it is all rooted in that preamble's acknowledgement of adapting to rapid technological advancements. But let's look at the actual trajectory of that technology today. The justice system, like every other industry, is undeniably moving towards automation and artificial intelligence.
It's everywhere now.
What happens when law firms begin using shared, highly advanced AI models to draft complex pleadings, analyze decades of case data, or even predict judicial outcomes?
Wow. Okay, my brain is already spinning.
How in the world will we define a conflict of interest when the exact same artificial intelligence, the exact same neural network, is simultaneously consulting for both the prosecution and the defense in a massive trial? Does an AI have a duty to fight and a duty to oppose? And connecting it back to our very first topic. If a law student uses an AI to generate legal advice under the limited legal services rule, who is actually practicing law? Who is the supervising lawyer exercising the diligence of a good parent when the student generating the work is an algorithm? The 2023 code brilliantly updated the rules for the digital and social media age, but the incoming AI age is going to require an entirely new philosophical foundation.
That is a genuinely staggering question to ponder. When the tool itself becomes the practitioner, how do you regulate its loyalty? We will leave you to mull over that somewhat terrifying vision of the future of legal ethics. Because as we've learned today, the diagnostic landscape of ethics is never simple, and it is certainly never binary. That clean, simple X-ray machine we talked about at the beginning, it's not just broken. In the modern, hyper-connected world of law, it is completely obsolete. We have to navigate these murky waters with a much more complex compass of trust, full disclosure, and unyielding accountability. Thanks for joining us on this deep dive into the source material. We will catch you next time.